number 24, the people of the state of New York versus Donna Middleton. Counsel, please remain at your stations. Yes, you may stand, sir. Argue from your point.
May it please the court, I am Mark Baker on behalf of Ms. Middleton, and I would respectfully reserve 2 minutes rebuttal.
You may, sir.
I think I can simplify this case beyond all the complex arguments in the brief. Here, the one act in the complaint that involved a single inmate in order to meet the prosecutor's obligations of setting forth non-hearsay allegations, establishing every element of the defense and the defendant's commission, the people relied on Ms. Middleton's rather rambling statement where she discussed 6 different inmates. But the only unnamed inmate in the complaint that even comes close to matching what she was referencing in her statement was inmate Chandler. Now, the only referenced inmate Chandler in her statement regarding the accusation and the complaint of disclosing that she disclosed information of an unusual incident on March 9th, 2015. But if you go to her statement on A7 of the appendix, it says in March 7th, 2015, inmate Chandler was transferred to another facility for ordering a hit on another inmate. I printed up the separation paperwork in the facility computer. Inmate Bell observed the paperwork and took it off my desk. Inmate Bell took the paperwork to his cell. She never did, according to her own statement, what the complaint said she did. The complaint said she gave it over regarding...
But why can't there be an inference drawn, given the entire statement, about her interactions with these several inmates,
because
about her desire to get into a good relationship with these inmates, even if it's not sort of intimate? Why isn't it a reasonable inference that by leaving it on the table or her desk and him taking it, because she didn't stop him, she didn't report it, she doesn't say any of that in her statement, and knowing he took it to the cell, that there could be an inference one would draw from that?
Because it doesn't establish, Judge Rivera.
Well, does it have to?
It does. It has to establish her commission and the crime by non-hearsay evidence. The complaint was very circumscribed.
We're talking here about an intent to benefit, right?
Yes.
Mr. Baker, yeah, we're talking directly about an intent to benefit.
That's correct.
This case, we'd all agree, it boils down to that, right?
That's correct.
And the way I understand the case law is that the act itself can show the intent. And there doesn't need to be a statement. The people never have to show that she said that she intended to benefit someone. What they have to show is that by her actions, you can infer that there was an intent to benefit herself or a third party. The third party, the intent would be the benefit would be friendship, the relationship with the people that she was involved with, and the intent was clear by the act that she took. That's the way I understand their argument.
Well, first of all, there's no intent demonstrated by another inmate seeing something on her desk and taking it. That's an inference that Judge Rivera was suggesting, which I don't think fits the facts of this case.
Well, why isn't there an inference from that? That is, she printed it out, the inmate's in her office, she sees the inmate take it, she doesn't report him. This is what Judge Rivera is asking. Why can't we infer from that an intent to benefit that inmate or some other inmate?
Well, if we want to get to intent to benefit, let's discuss that for a second, because Judge Fahey's saying that should be implicit based on the facts. 20 years ago, I lost the FERA case in this court. I hope I learned from it a little bit. And the fact of the matter is, in this case, there is an ambiguity because there's 2 benefits that, according to the people in their response to the motion to dismiss, fit the facts in this case. Number one.
Are those two benefits? I know you're talking about whether it was for her own companionship or friendship or relationship versus whether it was to assist the one or more inmates. But aren't those two coextensive? Why would that be? Why would they be inconsistent with each other?
We're talking about notice of what you're charged with in order, A, to defend against it, and B, to be able to determine if you're in.
But if they're not mutually exclusive, she's charged with both. And why isn't that sufficient notice to defend against both?
She's not charged with both. What the district attorney did in response to a motion to dismiss, where they alleged that there was not a specific or comprehensible benefit under FERIC, which is the case that was discussed, your Flanagan case, Madam Chief Judge, dealt with more of the authorization issue. FERIC dealt with the intent. Now, in FERIC, it was clear what the intent was because the court determined that the police officers acted contrary to what they were directed to do, and they wanted to get this radio back, which was clearly something that they would have benefited from. So the intentional benefit is here.
I may have misunderstood. When you first started arguing, you were talking about, I thought, some ambiguity about what the paper was that was provided to the other
That's correct.
inmate. Is that the same as
That's my
intent to
first-
benefit?
No, it's a
That's what I
separate-
thought.
It's a separate
Okay.
argument. I thought
Okay.
I
So
thought I
you're
would,
talking about notice of what it was, of the actual act.
Well, with my first argument, I'm suggesting that the corroborating statement, which rambles on
Right.
about all these different inmates, many of which she's saying, I didn't do that because I knew that would be inappropriate, doesn't support, and I don't think it allows for the inference that she purposely disclosed something. It said the inmate saw it on her desk and took it. That's just different.
Well,
From
isn't that a violation of the employee manual?
Well, then we get into the Rossi issue, which
But let's just stay with this for a second, all right?
Sure.
Letting an inmate, taking something off your desk for his own purpose, which is an official prison document, is a violation of the employee manual. I thought that was straightforward. You
Well-
wouldn't disagree with that?
it didn't say she let him. And it doesn't say where she was.
Well, she
when he
didn't
did
report it, right?
The statement is very quick and succinct.
See, well, the
Inmate
whole let him thing is-
observed- I'm sorry.
Well,
Mr. Baker, the whole let him thing is back, we're back to that intent argument again, and that's why I think it's Hatton, Dumais, those cases make very, very clear that an intent may be inferred from the act itself, and the act of not reporting it, the act of not complying with the employee manual that she signed and verified, and it's in the information. It makes it a more difficult case, I think. I thought you were arguing, to be honest, that there wasn't notice as to what the benefit was, and that two different people, that one county court clarified it as one
That's
thing.
exactly right.
That's the argument I
Yes,
thought you were
On
making.
the question of benefit, that's where I was going.
Okay, well, get there then. Go ahead.
Okay.
Yeah.
The benefit that the people said were arising out of these facts were a personal benefit, that she had new relationships and fostered relationships with these inmates, and also benefit to the inmates themselves. And as you said, the
I'm not sure I agree with that. I'm just giving you your argument.
Well, I'm just taking what the facts were as
All right.
litigated by the people, and then found by one judge, the town court judge said it's for her, and the county court judge said...
Here's the problem with the argument. The town judge said one thing was the benefit, and the county court judge said another thing was the benefit. They're two sides of the same coin, but the question is kind of, it doesn't matter if there was a benefit, does it?
It does, because she has a right to know specifically what she's charged with.
Well, if this case went to trial,
Yes.
wouldn't we allow the jury to decide what, if any, benefit she intended?
Well, I don't believe it should have gone to trial, because I think there wasn't a sufficient
Well, I guess what I'm saying
instrument on its face.
is that it seems to me that you're asking for a specificity in the accusatory instrument that I'm not sure that we've ever required before with regard to intent.
Which is precisely where I was going, because what you have here is admittedly so by the defendant, bad judgment. And Feerick said that is specifically what is precluded from the official misconduct statute. No matter how heinous, no matter how, Judge Fahey, if she violated directives in the manual, that's administratively remedial. But it doesn't amount to obstruction of justice as
But
a crime.
isn't, I think what Judge Fahey's getting at with the manual, isn't that would be a misdemeanor? That's evidence that we can use to infer something from this document. So the fact that she didn't report it goes to what can we infer from the fact that she left it on her desk and somebody else, another inmate, took it, right?
It's sloppiness, but it's not, we're talking about, what did Feerick say? The statute erects high barriers to prevent a criminal court from reviewing mere errors of judgment on the part of...
Right, and I think if she had been charged with a mere error of judgment, that would be a relevant
But she's
case,
not.
but she's not.
Her responsibility as an ASAC counselor was to, as she said in her statement, she's got 2 groups of 18 inmates a day, where she's counseling them on alcohol and drug abuse. That's her responsibility.
And then why
to
would
do
she
that-
print this document off and leave it on her desk? I mean, that all goes to what you can infer from the facts in the complaint. But getting back to intent to benefit, so if there is an act alleged, and it's, something was given to an inmate, which clearly is a benefit to the inmate, and it says, I do this because I want friendship and et cetera, do the people at some point have to choose in that document and say she did this solely for the purpose of benefiting herself, or she did this solely for the purpose of benefiting the inmate, because otherwise we're going to have this problem?
I think it has to be in the instrument, and it's not here. My adversary, if she's true to her brief, is going to tell you, well, we fixed it in a bill of particulars, or in the discovery of the phone transcript. But this court has said in Alejandro, a bill of particulars does not salvage an otherwise deficient accusatory instrument. And it's not there. It's simply not there. What you have is bad judgment. That's
But
what
my
it's
question
charged.
is-
But
if
in
you-
Fierick, the court said that it was enough. You're right about the statement of the law. I'm not disagreeing with you about that, about, bad judgment is not going to be satisfy the legal threshold. But in Fierick, of course, it's not about the charging instrument, it's about the evidence, and the court does say that it's enough.
No, what we argued in Fierick was that there had to be a corrupt motive coupled with the intent, and the court held that that's not true. It's a benefit, and here it was quite pointed. They wanted to get the radio back, and the court explained how they could benefit. There's no explanation here.
Yeah, but in her
It's
statement,
totally ambiguous.
one can infer from her statement that she is indeed, and she says, she's trying
Her
to have
statement-
this good rapport with
Which she needed to
various
do in order
inmates.
to be an effective ASAP
Sure,
counselor.
that could be her defense at a trial.
Yes. But
Well, the police
but
needed
she
the
didn't-
radio back to be effective. I
It
mean,
comes down to where, hopefully we're not having disagreement beyond our argument today. It comes down to what she said in that statement, which you said, Judge Rivera, you started off by suggesting it's inferable that she meant to do it purposely. I think that that's a quantum leap.
Yes,
when we're
but
talking about
if the statement was only, I printed up this document, I put it on my desk, the inmate took it and took it to his cell. There, I think you have a stronger case. But in the context of everything else she says, and she doesn't then say, and I reported him when he did it, when at other times in the statement she's saying, I told him I couldn't do that. I knew I couldn't do that.
That's after the fact. What we need to focus on, I respectfully submit, is what happened at that moment. And at that moment, she doesn't corroborate the complaint. There is no non-hearsay allegation establishing that element. I think inferring from that is a quantum leap. And I asked the court, I see my time is up, there is a statement in People versus Jackson where the lower court's 35 miscellaneous 3rd 179 said, contrary to defendant's argument, the court is not aware of case law requiring the accusatory instrument to specifically spell out which factual allegation constitutes the benefit. That is the current state of the law. But I submit that aside from a Fierick case and other cases that I cited, where it's clearly understandable what your alleged benefit is, it's not here. By her saying inmate Bell took it, how does that benefit her and how does it benefit Chandler?
Thank you, Mr. Baker.
I submit it doesn't. Thank you.
Counsel?
May it please the court, Lauren Consul, New York Prosecutors Training Institute, of counsel to respondent in this matter, District Attorney Anthony Jordan of Washington County. Your Honors, this is not a case about poor judgment.
Looking at the 4 corners of the complaint and the attached statement, and limiting it to that, what are the factual allegations that you're relying on to say that she had an intent to benefit herself?
Your Honor, those allegations would be that this defendant had a position as a program aide. She used that position to disclose information that she knew was to be safeguarded. And to be clear, she didn't just know that inmate Bell took the paperwork off her desk. She knew he had it in his cell. So that is another factual piece of information that we can infer her knowledge and disclosure
But how
from.
does that benefit herself?
How does that benefit her? It garners her favor with the inmates. And you will see in the four corners of the information, she does discuss various inmates. And as to one, I believe it is Jones, she does say that he told her he loved her. She said, right back at you.
Well, see, those remarks, I'm not sure I agree with the judge, but I think that the judge is right, that those remarks can't really come in from the telephone conversation that was recorded. That's what you're talking about, right?
No, Your Honor, I'm talking about that particular remark is in the accusatory instrument. I understand and I
Well, then
agree
you're
with
all right, then you're all right with that. But
Yes.
I think really ultimately here, what do we mean by a benefit, I guess is what we're talking about, right?
That is correct. And we have.
So what do you mean? What do you mean by a benefit?
Well, I think it's very clear from the accusatory portion combined with the factual, with the deposition and
No,
the
this is
factual
really
portion.
straightforward. Can
The
friendship, let me finish. Can friendship be a benefit?
Absolutely. Absolutely. And I believe there are cases that are cited in our brief where a romantic relationship can
But
be.
that's not really, it's certainly not in the accusatory instrument, and it's not, can we imply the benefit of friendship in and of itself, is that sufficient? I think that's the question for the facial sufficiency of this instrument.
Yes, I believe we can because there is additional information there in this instrument that demonstrates she is doing various favors for inmates and was only charged with this particular disclosure of an unusual incident, which, by the way, was a slashing and, is a serious offense. She talks about the fact that several of these inmates are gang members. I mean, this was very dangerous information that she was potentially passing on, and she knew that.
So Mr.
She-
Baker says that her doing this is part of her job. Does that change whether this is really a benefit to her?
Absolutely not, because she is not authorized by her job to print out these documents and distribute them to inmates, period. I don't think in any way, shape, or form that can be couched as her job. Certainly, would she need
As
to
I
form...
understood, the form was taken by Bell, and it involved Chandler. Is that correct?
Yes, that is correct.
And what did the form say?
The form was regarding an unusual incident on a particular date, which we see was regarding slashing or some type of stabbing incident at the prison.
So
I see.
what confuses me about that is that the complaint says that it has to do with an unusual incident, and her statement says that it had to do with separation papers.
The inference
Is that-
there
is
is...
that- yeah, go ahead.
It would be that that would be the incident that caused the separate, so it would be part of the separation papers, because it indicated that Chandler was transferred to another prison because he ordered a hit on another inmate. So presumably this incident was involved.
And that would give her sufficient notice of what you were talking, I found that confusing, so I guess my question is did that give her specific notice of exactly what act she was accused of committing?
Well, Your Honor, because it is spelled out in the complaint that they're talking specifically about an unusual incident report at a specific date, I believe that is what, it's certainly sufficient to charge her with that. If they wanted to, later amend or supersede and include all of the separation paperwork, certainly they could have done that. But as to this, my assumption is that's probably the most critical part of that paperwork, which is why.
Let me ask you this, because it seems that if I'm understanding counsel's argument correctly, the issue really is how specific do the allegations of intent have to be?
Your Honor, that's exactly what I was going to start with, is that this is a defendant who received an extremely advantageous plea bargain and now wants a new rule of particularity that has never before been enforced by New York law in order to vacate her conviction. And the standard that we have is that you need to establish reasonable cause, that the person committed the offense, presuming that what is in the complaint is taken at face value.
Well, this is the prima facie requirement, though, isn't it, that we're talking about?
And then also, you do need to establish a prima facie case,
Yeah.
and we have that here. And we have.
Can you give me an example of an official misconduct complaint from which intent could not be inferred?
I suppose if you had a distinct act and you had no background for why that act took place or where it took place or that there was no employee manual, if you were absent a lot of the explanatory and surrounding facts that we have here, certainly it may not be obvious, it may need to be spelled out.
Sort of like what happened in Jones.
Yes, Jones, I believe,
That was a disorderly conduct.
that was the one, yes, where they did not make out what exactly the action was that the person was doing that constituted, I forget the exact language, but a disruption to the public, essentially. They just said, I believe that's the one where he was just standing and, blocking the sidewalk. And they never said that he was causing a disturbance by blocking the sidewalk or that he was somehow otherwise fitting in the statute. They just simply said he was blocking the sidewalk. So therefore, we wouldn't be able to infer just from him standing there that he was causing whatever the specific language is. I forget off the top of my head, but intend to recklessly create a risk of public inconvenience, annoyance, or alarm. You can't really infer that just from someone standing. So that was why it was deficient in Jones, very different from
So it has to do
here.
with context.
Absolutely.
In a general sense. And here you say that her statement provided that context.
Absolutely, and what defendant is asking for is essentially for there to be either an arrow drawn between the accusatory and factual and attachment portions of the information, or for there to be additional sentence that says the benefit is X. That is not something that is required at the pleading stage ever in the case law that we have here from this court and other courts. And in many instances, for practical purposes, at the pleading stage, we're still investigating, we're still gathering information. We may not, and again, there could be mutual benefits as we have here. These benefits go hand in hand. They are not mutually exclusive, they're not in conflict, and in fact...
Counsel, so just so I can be clear, so we're going to come back a little full circle here.
Sure.
Just reading the information and the attached statement, the people's position is that the benefit was what?
That the benefit was to help the inmates and garner some type of favor or relationship with them.
So both?
Absolutely.
A benefit to herself and a benefit to a third party?
Correct, and either one of those would have been sufficient to me. And it only actually has to be an intent to benefit.
To the third party, who's the third party?
The inmates.
All of them?
Well,
So
in
releasing this one document benefited all of the inmates named in the statement?
No, in this particular incident, it would be the inmates involved with the unusual incident
And
report.
how would she know that? You're saying she would infer that from the fact that it's the unusual incident document?
Because the factual portion of the allegation does spell out that the charge is for disclosing to an inmate regarding the unusual incident report on a specific date.
So how is Bell benefited?
Well, Your Honor, we don't know that.
From the four corners of this, how is Bell benefited?
He has information he's not supposed to have as an inmate. Very simply, I mean.
So it doesn't really matter that this particular document is the one that he picked. Any document that included information that inmate didn't have access to would have been enough.
Coming from the computer system at the prison, absolutely.
Yes, because he wouldn't have had access to it, that's what I'm saying.
Absolutely. Yes, Your Honor. And in fact, it's not a benefit that even has to be tangible or executed. It's an intent to benefit. So clearly from this statement, we have an intent to benefit. And I see my time is up. If Your Honors have no further questions.
Thank you, Ms. Constable.
Thank you.
Mr. Baker?
My adversary is creating benefits for inmates that are not the subject of this prosecution. For instance, in support of their position in response to the motion to dismiss on page A32, it can be implied from the defendant's statement she received an inferred benefit of companionship, friendship, potential. I love you. I told him right back, I love you. But that has nothing to do with Chandler. If you go back to defendant's statement, that was dealing with inmate Jones. You got to remember something, Your Honors. This is a woman who worked in a very dangerous environment. In the beginning of her statement, she talks about how she was scared by one of the inmates who was performing a sexual act in her presence, and she got quite intimidated. It's very important for her to function as an ASAT counselor, to have a good relationship with these people. So by her saying to an inmate, I love you back, that's only protecting herself. And it's not the benefit that's alleged by the Chandler complaint, but it's what the DA relied upon in order to justify the legal sufficiency of this instrument. I submit to you that under these facts, if this is upheld with such an amorphous benefit that only comes in later, it's in effect taking a strict liability offense out of, making it into a strict liability offense out of this crime, which requires very specific intent. Dual. She has to know what she's doing is unauthorized, and I submit she didn't admit to doing anything unauthorized. The inmate Bell took it. And B, she's got to intend a benefit. The intended benefit that the district attorney suggests and one of the judges embraced has nothing to do with the subject inmate in the complaint. Thank you very much for your attention.
Thank you, counsel.